I can rewrite it. Please see below 7.7, para 7.7. Your Lordship have it? Yes, page 473. Therefore, it appears that the claimant requested that the recommendations of NICMAR be applied to modify the formula stated in the contract agreement. And the officers of SMC did consider sympathetically the C's claimant's demand in that background. The formula gives him 30% escalation. We agreed to take it to 40. He wants 55. So, my lord, he said that the formula should be changed so that I get 55. Please read further, my lord. There was nothing wrong in that approach. In the background of what has been stated above, taking recourse to NICMAR recommendations to modify the contract escalation formula cannot be considered unreasonable. The claimant has done so. It is correct that the SSNL had agreed with recommendation of NICMAR in order to give incentive to the contractors to complete the works in time, and therefore an MOU had also been prescribed. If the corporation officers did not do so, they must be having their work-specific reasons. MOU was not a must for making use of recommendation of NICMAR to modify the contract escalation. My lord, NICMAR was a recommendation for another project, which was Sardar Sarovar project. We have a contract of our own in which there is an escalation clause 35. The arbitrator says I can rewrite it. The learned district judge says nothing wrong with this, it's very fair. The High Court, my lord, division. That's why the High Court says that you can't rewrite the contract. May I show that contract also? That is right. And the arbitrator proceeds on the basis that he is modifying the price escalation formula. 2 pages. Lord, it's all right. May I show and page F, Lord, of the synopsis, para 4, they also say the same thing. Their understanding is that the formula has been revised, needs to be revised. Please see para 4 at page F. The Honorable High Court failed to appreciate that the present case was not a dispute, that the learned sole arbitrator had gone beyond the terms of the contract, but was instead a question of fact as to the extent to which the price escalation formula was to be revised. The learned sole arbitrator, based on detailed evidence submitted by the parties, revised the price escalation formula after consideration. You also accept the fact that the arbitrator revised the price escalation. With respect, kindly have the clause. The clause is not applicable. Kindly have the clause. I'll just show your lordship 2 pages and if the clause is not applicable, then how do you play it in price? Because the clause I gave 1.95 clause is paid. 1.95 clause is already paid. Another 51 lakhs we have agreed. He wants a lot even more than that. So I paid him 1.95 crores. Your lordship, give me 1 minute. Kindly see, Lord. This is a claim arising. Lord, kindly give me 1 minute. Just so 1 minute. Maybe now see the matter. Thank you. This is well after the contract. Item 13 and I'm okay. Item 13. You should note it in the connected matter. In 13, the identical point. Fixed in the second week of November. 12 November date is. It's an interim order constituting a committee by the High Court.
We have a difficulty in that because the neutrality has been completely given a go by, which was what the single judge had done. If your lordship just see, the single judge in 2 batches. There were 2 batches, your lordship.
जी हाँ दोस्तों, इसमें जो है सेकंड नंबर ऑफ वीक में डेट दी गई है. चलिए मिलते हैं नेक्स्ट अपडेट में.
Representatives and Calcutta University, because Calcutta University were board's nominee.